All right, well, good morning, everybody. This is Brad Rustin. I'd like to welcome you to our continuing In the Trenches series. Hope all of you are gaining something as we have these twice weekly presentations on compliance and financial services topics that are facing various participants in the financial services industry in the wake of the coronavirus and COVID-19 crisis. Want to thank all of you who joined us earlier this week for the Main Street Lending Program. We had tremendous turnout for that, and are looking forward to working with a lot of you as you start to implement your Main Street Loans programs. Today's topic, though, shifts back to more pure compliance. And today we're specifically focusing on debt collection, some of the Fair Credit Reporting Act or FCRA concerns, particularly as we work our way through the pandemic and the crisis. I'm joined today by my colleague, Craig Nazzaro, who many of you know from our past In the Trenches series. And we're really going to kind of talk about each of those two in turn. So in terms of where we're going today, we're going to talk a little bit about why this matters so much over the near term, next 60 to 90 days. And then we're going to shift to talking about what we learned during the last crisis, what you should be focused upon based on existing regulatory enforcement actions, where the CFPB is heading, what prudential regulators are looking at, and then some practical advice in terms of what are best practices, things that you can be doing now to make sure that as this cycle begins to work its way through, we're not getting caught in any sort of compliance or regulatory trap 60, 90, maybe a year out when you have your next exam. We go back to kind of our existing slide. If we look at how consumer debts tend to trend with unemployment, we see that as unemployment, the dark green line there, goes, so too does defaults on various consumer debt obligations, as well as, to a certain extent, commercial debt obligations. Particularly here, given the recent spike, we're seeing a pronounced increase in the number of consumer defaults that begin to start to cycle their way through the system. Looking at some of the earnings reports and call reports that came out recently, we see that there is a significant jump in the number of auto loan defaults, the number of credit card defaults, all are already increasing. The data here is through Q4 of last year, because that's what the Federal Reserve tends to collect and aggregate across the United States. But what we're hearing from the front lines is that we expect this continue to increase. If we tend to model out these default risks, looks like, should be expecting, at least in the near term, somewhere around a 10% default rate on most of those consumer line products as the rate of employment continues to increase. According to the Bureau of Labor Statistics, given the unemployment numbers that came out this morning, we're expecting U.S. unemployment, when it finally gets computed, to be roughly 15% as of today. But the real question is, so what does this mean? We're collecting data as we speak on mortgage default and loss mitigation. And what we see is that there has continued to be a growth in the number of loans that are in forbearance on the mortgage side. We went from 3.74 to most recently 6%. If you compare that back to March 2nd, 0.25 or 1/4% of mortgage loans are in default. So the net effect of that, if you think about where that went, is a 24x increase in the number of mortgage loans that are in forbearance over that short period of time of roughly 6 weeks. Same thing we're seeing from Ginnie Mae, increase from 5.9 to 8.25%. Same thing we're seeing at Fannie and Freddie, with conforming, traditionally some of the cleaner mortgages that are living out there, already going from 2.5% to just over 4.5%. Interestingly, the service or call center volumes have been decreasing. This may be a result of individuals getting their stimulus checks. This may be a result of people beginning to settle into what amounts to a new normal. But interestingly, we've seen that the call center volumes have tended to decrease. Hopefully that's a sign that things are beginning to somewhat stabilize into this new normal. The real question all of us obviously are asking is going to be how long this lasts and where this goes. When you look at how many loans are in forbearance compared to portfolio volume, this one is particularly instructive. If you look at banks themselves, you've seen almost a doubling of the number of loans that are in forbearance. Part of this is federal programs that have made it much easier to gain a forbearance, but it may also be a sign of things to come. Craig, I guess I'll turn it over to you, and if you would, give us a little bit of an overview of the Fair Credit Reporting Act, some of our obligations, and we'll start talking about how that's going to be triggered in light of the current circumstances.
Sure. So just as a general overview, the FCRA has been around since 1970. It was promulgated to promote accuracy, fairness, and privacy of information in the files of consumer reporting agencies, and also how to promote the commercial need for consumer reports. One thing to highlight as we go through the FCRA overview is both the regulatory and litigation exposure. Unlike other consumer protection, consumer lending statutes, the FCRA allows a private right of action for consumers. So you start to see a lot of individual litigation, some class action litigation. You see this a lot with plaintiffs' attorneys' firms, just aggregating and capitalizing off any area of the FCRA that's hard to comply with, especially for growing lenders that are struggling with FTE capacity. It's good to note, just as you grow and as you settle into FCRA, that that private right of action has a statute of limitations that's not so bad. It's within the earlier of the 2 years after discovering the violation or 5 years after the violation has occurred. Brad, next slide.
You know, what we saw last time during the last financial crisis is that as we saw an increase in defaults, you saw a number of borrowers who were turning to counter litigation or offensive litigation against lenders in order to try to use that as tools to defend against foreclosure, to defend against collections, to defend against repossessions. And so we expect that same trend to continue here. I mean, already we've been monitoring certain large consumer finance plaintiffs firms that have already begun soliciting clients to try to either work with them on debt restructuring and debt collection mechanisms, or soliciting them to file class actions against creditors that or debt collectors that may be caught up in some of the impact of COVID-19 that's leading to regulatory violations. You know, one of the important pieces of this is with the baseline requirement of Reg V, which implements the Fair Credit Reporting Act, is you have to establish policies and procedures. Now, interestingly, much like what we see in the AML or BSA context, those procedures are supposed to be scaled and appropriate to the nature, size, complexity, and scope of each of your activities. So what that means is, you know, what may be applicable to one of the big 5 banks may not be applicable to a smaller auto finance lender or an unsecured consumer installment lender on a more smaller scale. And it also is dependent on how you report credit, what actions you're taking, how you are using that credit, and how aggressively you are engaging in that reporting. But understand one of the issues here is as the complexity of your reporting and your structure increases, so too do your policies and procedures need to scale up appropriately. And so if you're moving to remote working, if you're moving to a more aggressive collections policy, earlier intervention, additional accommodations for borrowers, all of that needs to be reflected in your policies and procedures. There's a really good appendix that describes these policies and procedures and how this works. We've linked to that here in the presentation so that you can access it after we conclude. But it's a really good guidance issued by the CFPB that gives us some oversight as to that. Craig, you want to talk about direct disputes?
Definitely. The one thing I would add to the policies and procedures discussion is just that with that private right of action, you get to leverage these policies and procedures. And when you're writing them, think about what you'd want to showcase if you do see a class action or if you do see an increase in litigation over your credit reporting activities. If you don't have evidence, of proper regulatory conforming to the regs, you can produce your procedures to say, you did have procedures in place that should have adequately controlled the credit reporting operation. Now we can move on to the next slide. The FCRA also governs disputes. Given the fact that we're shifting to a default environment and we see defaults increasing week over week, you're going to see the regulators increased interest in how you're handling your disputes and what you have around your disputes. So it's a good time to revisit what your requirements are. So for direct disputes, disputes that come directly into you as a furnisher of credit reporting, you have a duty and how to respond. So after receiving a dispute notice from a consumer, you must conduct a reasonable investigation. That reasonableness is not defined within the regulation, it's defined within court cases. Later we're going to link to CFPB guidance that kind of shows you what you can build internally that would be reasonable to have around your investigation process. You have to review all relevant information provided by the consumer with the dispute notice, so you have to look into every single allegation. Complete the investigation within 30 days, and if you find any problems resulting from the investigation or that you reported the credit incorrectly, you must update all the CRA agencies that you put that information out to and properly reflect the reporting the way it should be.
You know, one of the things that we saw during the last crisis is the number of disputes you're going to receive. You know, particularly as loans start to default and you tend to engage third-party collectors, or you potentially are selling your debts to third parties. These debts are moving around. Credit history is beginning to report more negatively against consumers. You're going to see an uptick in the number of disputes because consumers will be actively monitoring those credit files. And so it's natural that the offshoot of the current conditions are going to be a significant increase in the number of disputes you're receiving. You know, similarly, there are times when you don't have to investigate a direct dispute. One of the things we saw in the last crisis was disputes that people were downloading online, their entire websites that talk about how you dispute credit files, how you dispute credit, and it's used as kind of a diversionary tool in an attempt to try to, quote, trap debt collectors or lenders and holders of debt into one of these traps. But understand, it's not an absolute bar. There are certain protections that you have in place. And it generally involves, if the dispute relates to your reporting of credit, you must respond to it. If it's just simply the consumer asking for a copy of their credit report, they want to talk about employment histories, information that's biographical, that's maintained by the CRA, information on public records, such as if you had filed a foreclosure against a consumer and the state was reporting, or the CRA was picking up the state foreclosure filings. That's not up to you to investigate. They would have to dispute that with the CRA. Information about other furnishers. We saw a lot of this where you're not the current furnisher. You potentially were a buyer of the debt. You were a servicer. You know, there are certain obligations you have as a servicer, but then also consumers were tending to complain to you about issues that were reported from other creditors. It's obviously only what your entity has been reporting. And then information that's not submitted to the right address if they didn't follow the procedure. You know, one thing that caught a lot of our clients in the last recession, especially smaller lenders, is understand that under the regs, you have the right to set out an address for disputes. And that has to be communicated to the consumer through an enforceable means of providing that notice, such as in the loan documents or in regulated communications. And it should also be provided in the credit reporting information that you're providing to your CRAs, your consumer reporting agency. So when you input your data so that you show up on a consumer report, make sure you have a valid address on file. If either that address is not valid or you haven't gone through the process of establishing a notice address for FCRA disputes, there's kind of a trap that exists under the statute, and that is any notice to any business address counts as notice and puts you on the clock. And so make sure, one of the easiest things you can do to mitigate some pain, make sure you have that address in your agreements with your consumers, and it's also being accurately reported to the CRAs to which you're furnishing information. And then the last is obviously what we saw in the last recession, which is frivolous or irrelevant disputes. And Craig, you want to talk a little bit about those?
Sure. So frivolous or irrelevant disputes kind of really slow the process down. You have the ability to determine if a dispute is frivolous or irrelevant and not be tied to the direct dispute responsibilities. We have a little graphic here to say what you have, what can qualify as frivolous or irrelevant. The consumer did not provide sufficient information to investigate the disputed information. It's substantially the same as a dispute previously submitted by or on behalf of the consumer, and the furnisher is not required to investigate the direct dispute because one or more of the exceptions apply. Once you determine that it's frivolous or relevant, you must notify the consumer of the determination not later than 5 business days after making that determination. So you don't get the full 30 days. If your records indicate that it's frivolous the day it comes in, your clock starts running, you have 5 business days to do so. One thing that I would be careful with here is how you push this down, or what area within operations or what controls functions is monitoring this or actually applying this. The larger you get and the more your operations scale, if it's been one whole cycle since you've last looked at your controls here and you've grown significantly, an entry-level employee or first, the line that's actually talking to the consumers, if they have the ability to apply this, sometimes you see them relying on that middle exemption where it's a previous dispute that came in or substantially similar, where the borrower or the consumer may be raising a completely new claim later in the letter. It could be a cut and paste, and you get caught a lot with that if they're not reading through the entire dispute, or if it's similar but raises a completely new allegation, and you start to get hit with that if you push this control too far down.
Yeah, one of the things we've done with best practices with some of our clients is if you're going to reject a dispute based on the frivolous or irrelevant determination, make sure there's some escalation before that first party sends it out. Because as Craig said, there's a couple of traps you can get into there. The other one we saw in the recession is that first one, which is sufficient information. There's been some fairly broad interpretations of what counts as sufficient, meaning, the consumer didn't provide every exact detail, but you could reasonably infer what the consumer was disputing. Oftentimes that can lead to some potential liability if you didn't make some level of investigation. It's not just something as simple as, well, there's no account number, therefore we can't figure out who it is. If you had other ways of making that determination, you can fall into that trap. Understand, though, when you get an indirect dispute, these are ones that are coming through from the Consumer Reporting Agency, the CRA. The CRA does have protections very similar to those provided to you as furnishers of information. But understand, once the CRA has made a determination that they're going to cycle the dispute over to you, the so-called indirect disputes, they often come through the eOscar platform, which is the electronic interface platform with consumer reporting agencies. Once they have made the determination that that is a valid dispute, you yourself don't then get to re-examine those disputes. You have to, under your contracts with consumer reporting agencies, then respond to the CRA. And there's an extremely helpful little timeline here that the CFPB provided and some guidance back in 2017 that we've kind of pasted here for your reference. But just understand that the concept is, comes in from the CRA to you, they are going to send you a notification within 5 days that you need to respond to them. You then send a response back to them, and they respond to the consumer. So that's why it's considered an indirect dispute. Make sure you have a process to clear these fairly quickly. One thing we've seen catch a number of our clients recently is with folks working remotely, with compliance being highly fragmented at the moment. This is becoming something of a concern because a lot of those people who were inside of your locations processing these indirect disputes may not have clear access to this, may have trouble getting on, and some of these controls may be falling down as we all go to a remote working environment. Craig, back to you.
Sorry, I was on mute, Brett. Just to go back to that last slide real quick, that graphic is not only for the illustrative purposes, but if you are a growing entity, or if you don't think your policies and procedures are going to be adequate, or you're just starting to build them under the required procedures and furnishers that we mentioned earlier, this graphic is a good way just to outline them and kind of build out your procedures from this little chart from the CFPB. We can go to the next slide. Also, there's a lot of dispute guidance by the Bureau out there. And just so everyone's aware, if you're not regulated by the Bureau, or if you're a depository that's under $10 billion, or if you're just not under the CFPB supervision, the guidance still applies for FCRA. It's something you're going to want to read through. Back in 2013, the Bureau was receiving a lot of complaints around credit reporting coming in through CRAs or indirect disputes. So they issued the guidance that's highlighted there in the first bullet point. It's very, if you haven't read it, go through it and make sure that your procedures reflect what's in the guidance. After 2013 and over the next 4 years, the CFPB really didn't see a decrease in the issues that they were seeing during their supervision activities or their enforcement activities. So they dedicated a full issue of their supervisory highlights to consumer reporting in the winter of 2017. This is also a very good reference if you are revisiting your FCRA procedures or your policies or your controls. If you're not familiar with the supervisory highlights, they will review everything that they've seen over their supervision history of the last 12 months and kind of bullet point out for you what the common pitfalls are, what the procedural gaps are, and how they dealt with that within the supervision process. Well worth going through and revisiting now that you're starting to see more defaults within our economy and shift to a default focus.
You know, and that's really a great top tip there, Craig, which is if you're not watching those supervisory highlights, it really isn't insightful to see where the Bureau is going in terms of, you know, it's kind of their way to, without formally communicating through public enforcement actions, where they're viewing their targets currently and in the near term. And so it's just great for anyone who's in the compliance space. Make sure you're monitoring those supervisory highlights and use it as an early warning tool, if you will, that may indicate what's going to be coming in the near term, or even things that may not be public yet that they're focusing upon.
It's also great to throw in there when you're in the room with the examiners and they're doing a look back and they ask you that question about change management, you know, how are you staying on top of the reg? It's really great to just say, well, we follow your supervisory highlights every quarter as part of our program and implement anything that you've highlighted for us. That always goes over well.
Yeah, it gives them a warm, fuzzy feeling when they're talking to you.
Exactly.
You know, kind of in line with that, the CFPB has been trying to provide some accommodations with an understanding of what's going on right now currently in the economy and with the financial services sector. And so there was some guidance that came out beginning of April from the Bureau that was a statement very consistent with what a lot of the other prudential regulators did, as well as the state regulators, regarding their priorities. And in essence, they're saying they understand that reductions in staff and the difficulty in kind of considering disputes and then getting access to information may be challenging the process of fully investigating both direct and indirect disputes. The Bureau says that they do not intend to cite in examinations or bring enforcement actions against individuals that may have had technical violations of these requirements, though they were making good faith efforts to investigate disputes as quickly as possible. You know, one of the things Craig has continued to reemphasize, particularly given his background kind of on the front line in one of the big five banks during the post-crisis last time, is this is all well and good until you get about a year to a year and a half out. Then suddenly all of these controls begin, the CFPB or your prudential regulators begin looking at these controls again. And so, yes, there is some basis for understanding that there's some expected relief, not something you want to 100% rely upon here because it could put you in some traps. And so you need to be planning into the future. And as soon as you have the capacity to start checking these controls, moving back to normalcy, make sure you're doing that and you're planning your regulatory and compliance cycle to take that into account.
One thing I would add there too is some of this, the efforts by the regulators are being publicized. You'll see it on CNBC or various financial services news outlets. That always becomes a problem when I'm in the compliance role or supporting a compliance role or a risk role. When the operational leaders have access to the same information, you'll start to see pushback saying, like if you cite something in a monitoring testing report or an audit brings something to operations attention, you may start to see senior leaders within the operational unit push back, say, well, we're not really focused on that given the environment, and we have the regulators out there saying this shouldn't be a problem for us. I always, again, revert back to the language, even within the guidance here, that they intend to not cite this with an examination, or if you're making your best efforts. Like, this is not a free ticket to just ignore the control for the next 6 months. They're going to look at it, and they're going to quickly forget that this guidance even exists, as Brad said. The FCRA amendments also under the CARES Act are very important to review, digest, make sure your procedures are reflecting these changes. We've outlined the changes here. It's not that much. The first thing that they revised is added 2 definitions: an accommodation and a covered period. The covered period begins January 31st, 2020, and continues to the later of 120 days after the date of the enactment of the subparagraph, which would be sometime later this year, or 120 days after the date on which the national emergency concerning the COVID outbreak was declared. So whenever we come back from the national emergency, once that's declared complete, you have 120 days from that date on. Up until that point, you're going to have to comply with what's on the next slide, but make sure that your procedures are reflecting these changes. Make sure that your operational units are aware that these are out there.
Yeah, and to that point, Craig, I mean, it's really important that you immediately put in place some training, excuse me, as well as procedure modifications to reflect these. I mean, these are immediate changes with immediate effect, and you need to make sure that your operational units understand that these changes are impacting how you're doing consumer reporting, especially where you have automated consumer reporting, where you're using software to generate your, if you're reporting to the major CRAs, your Metro 2 reports. A lot of that is being adapted in real time by those software providers, but it's something you really need to be cognizant of, because these are not, notice of proposed rulemaking. We go through our normal kind of compliance resource management systems where we're going to investigate and determine the impact. No, these are live, these are now, and need to be complied with. Importantly are the changes that came about in the CARES Act, which is if you are making accommodations during this period of time that Craig just referenced, in essence, the period of time where there is COVID-19 impact, and the person is then going to either suspend payments, maybe you're doing a forbearance. If it is an accommodation as a result of those modifications during that period, you continue to report the credit as current. You don't report it as past due. You continue to report it as current paying as agreed. If, however, the person came in with a default prior to the opening of that time period, if they were, say, 30 days delinquent at the start, you continue reporting the delinquency that existed prior to the time period, but you don't then continue to add additional delinquencies onto it, because in essence, any of your accommodations during this time period do not count against the consumer. That's the way to think about it. This is kind of a protection for any accommodations during the response period, and in essence keeps the credit reporting stalled during that time. However, if the consumer were to bring it current and catch up on that past default, you do then have an obligation to go back and now start reporting it current, or having them brought current if they do pay it off. The one exception to this is if you had already done a charge off, then these obligations don't apply. So if you had already moved it into a charge off status, then you continue to report it as charged off, and this doesn't then somehow give them the benefit of not having it report.
This is interesting too, because it's completely opposite of what we heard from the regulators on the last go around in the financial crisis of 2008. We saw a lot of sightings of putting borrowers into modifications but not explaining the credit impact, or not disclosing that they would go negative when they entered a forbearance agreement within the forbearance agreements going out there. It's completely counter to that. So for people who were doing this 10 years ago, it seems a little odd. I believe it's driven by the belief that this is not systemic to the institutions itself, that the credit quality should improve once the COVID-19 impact is lifted. I think that's why we're seeing the differences, but it's just an interesting point that it's just nothing like we saw last go around. Another point we wanted to raise is adverse actions. So the term adverse action is used both in the Equal Credit Opportunity Act, as Reg B, as well as the FCRA. The term is broadly defined, but one thing that we'd like to note here is that under Reg B, an adverse action, the definition of excluded from the definition of an adverse action is that second bullet point there. Any action or forbearance relating to an account taken in connection with activity, default, delinquency as to that account. So if you're going to modify a loan, if you're going to go into forbearance, if you're going to change, recapitalize the debt, you're not seeing a new extension of credit. So you're not going to, let me rephrase that. Under certain regulations, it may be deemed an extension of credit if you're recapitalizing or if you're changing the underlying terms, but for adverse action purposes, it's not determined, it's not defined as an extension of credit, so you're not going to have to issue an adverse action. One caveat to that is if you start to see a lot more defaults in mortgage after you see this forbearance wave, if it goes into default, if it follows the same cycle as last time, you saw mortgagors trying to sell homes or have people assume homes when credit got tight, assume the loans that were on the homes when credit got tight. That assumption would be a new extension of credit. So while it is treated as a modification or a SEMA in some mortgage companies or some mortgage banks, the addition or the assumption of that underlying note is the new extension of credit. So if they were to be denied, you would have to issue an adverse action.
Yeah, and be aware too of potential refinances where you cross over from doing a forbearance or mod into what is legally a refinance under Reg Z, because then you potentially re-trigger these adverse action notices if it's occurring as a refinance and that refinance is denied, as opposed to a mod or forbearance. So just be aware that if you're going to use a new debt to replace existing debt, all of the AAN, adverse action notice obligations, continue to apply.
Yeah, if you don't have the FTE bandwidth or the capacity to throw a lot of bodies at the modification process as it expands in the coming months, it's best just to only deal with the people that are on the note and leave it at that.
A few kind of just before we shift over to FDCPA, a few things that kind of piggyback off of our presentation on updating your compliance management systems in the wake of COVID-19. But understand that particularly given the staffing and remote working environments, you've got to watch for things slipping through the cracks. And here's just a few kind of top-level pointers for your future reference. But just understand, given the unique working environments, that we have people with limited access to certain of our control systems that we have inside of our financial services companies. This is going to be particularly challenging. And make sure that you're continuing your training and your procedures updates as you can, just as quickly as possible, because so many changes are coming through that are of immediate effect, and it's not subject to our normal cycle of planning, implementation, and then rollout. Craig, you want to shift and talk a little bit about FDCPA? Craig, you still there?
Yes, sorry. Just as the FCRA, we're expecting a regulatory focus to shift to debt collection as well. As always, with the Bureau, debt collection makes up a large portion of their overall consumer complaint population. And that first bullet point there, you'll see that over the last year, January 2019 to December of 2019, they received a little over 75,000 debt collection complaints. They engaged in 5 public enforcement actions, 2 of which were initiated in prior years, but were dealt with and finalized within 2019. And that's even more impressive given the change in tone from the top from the CFPB. You switched, the administration switched over in 2016, and you're still seeing this focus on debt collection almost 4 years later now. And be very aware that if the administration changes over again, the Bureau is going to quickly shift to these high-risk areas and double down on these efforts. We also see that the FTC, who also has enforcement authority over the debt collection, FDCPA, had 25 defendants in various cases and obtained more than 25 million in judgments. On the right there, we have a graphic that breaks down those 75,000 complaints into six categories. It's a good way, a good indicator to see what the Bureau is focused on, or what your regulator is going to be focused on when they come in and look at your debt collection procedures or your collection procedures if you're a first-party collector. So just, focus your monitoring and testing efforts here. Review these procedures that touch on these topics. As you can see, attempts to collect the debt not owed is a driver. It's over 45% of the population. So you take heed to focus on that portion of debt collection.
And then when we look at kind of where those FDCPA violations fall out, here's what the CFPB is showing in terms of the last 12 months in 2019. What are those key issues that are driving enforcement actions? And obviously one that keeps popping up is that top one, which is false representations about the amount or legal status of the debt, meaning you're either trying to enforce debts that are time barred, it may be misrepresenting the age of a debt or misrepresenting the amount or status of that debt. And so, that's pretty easy to correct given appropriate controls and monitoring in place at your institution. But it's also one that tends to lead to some of the most aggressive litigation. Still, people to this day are messing up this issue of disclosing that communications are coming from a debt collector. If you're collecting your own debts, less of a concern, but certainly if you're outsourcing debt collections to third parties or you're selling your debt, this is something that's so easy to monitor, something that's kind of basic procedural, but we still see a huge number of compliance violations relating to this somewhat simple topic. And then finally, failure to send notices of debt, meaning that they're not sending the initial communications regarding the debt and the assumption that it's valid. Or responding to requests for validation notices. The nice thing is, as you look at these three, these are all very correctable with policies and procedures. I think what we see instead is the number of third parties that are being engaged to engage in either white label debt collection or true debt sales is increasing dramatically. And as a result of that, you're having a lot weaker controls because these third parties are getting more aggressive, particularly as we see this increase in defaults coming. You're going to see a lot more of those control failures. And it's not necessarily at your institution or your lender, but it may be with those third parties with whom you're working.
We also want to bring up the point around debt collection and that driver within the complaints where the debt was not theirs, that over 40% of the population. The Bureau in their annual debt collection report, which they're required to produce under Dodd-Frank, pointed out that the increasing population of that subsector of complaints is becoming more and more dependent on identity theft. That first bullet point there says that in 2009, it was 25% of that complaint population. It was 20% in 2018 and 11% in 2017. It's also good to note that the Bureau does not hide the fact that they use the complaint database as a driver for their supervision and their examination activities. So for best practice, you can kind of expect that given the fact that the Bureau is just telling you that identity theft is becoming an issue within debt collection, that they're using that complaint database to drive their activity, you can just expect that they're going to look at how you respond to allegations of identity theft within your debt collection practice if you're trying to resolve those or putting controls in place to resolve those as efficiently as possible for consumers, and just kind of focus your procedures and your controls on that issue because it's going to come up in 2020 and 2021.
We also see there kind of a perfect storm that's brewing, which is the crisis served as a shock to many of our lenders as well as financial institutions. And so everyone immediately then shifted over to a non-face-to-face environment. Everyone's trying to do online. Everyone's trying to do remote identity verification, remote logins, online servicing, mobile servicing, et cetera. The offshoot of that, and if you look at some of the CFPB guidance, some of the alerts, particularly that they've targeted to older Americans who may not be as technologically savvy, we expect there to be another significant increase in identity theft. One of the things we're going to talk about next week on our cybersecurity presentations is already we're seeing between a 25 and a 50% uptick in the number of identity takeovers that are occurring as people shift to an online environment. And so the natural offshoot of that is one of the easiest ways, if you steal someone's identity to steal their money, is to obtain credit in their name. And so if you don't have good, clear processes, either to identify customers and authenticate them, or conversely to investigate complaints or disputes coming in from those customers, we expect this will be a huge focus of regulators in the coming cycle, just given the pure volume we're expecting to see in this somewhat perfect storm. You know, when we think about the FDCPA, just understand that, you know, a lot of people in certain business units inside of organizations will say, well, that doesn't apply to me. You know, they're right. The FDCPA, most of the provisions apply only to consumer debt, not commercial, and it applies to third-party debt collectors, not individuals who are collecting their own consumer debts, not first-party collections. The response to that when it comes up is just understand the Bureau has said, you know, ha ha ha, well and good. Through our UDAP powers, our ability to pursue unfair, deceptive, and abusive acts and practices, we can actually go after first-party debt collectors for what we consider to be deceptive, abusive, or unfair practices. So not only does the Bureau kind of have a way of expanding its jurisdiction and back-ending FDCPA claims against first-party collectors, but understand that almost every state has a mini FDCPA. That somewhat varies by states, but in general, most of the states, when the FDCPA came out, implemented some sort of program that would implement a similar regime for first-party collectors. So, you know, FDCPA needs to be on everyone's radar, even if you're not a third-party debt collector.
To Brad's point about the CFPB utilizing or leveraging their UDAP powers, and as well as the expanded focus that we're expecting to see in data security and identity theft, we just wanted to point out again, it's an enforcement action from 2016. Some of you may remember the Dwala consent order. No one was expecting the Bureau to take action for a payment processor that had shortcomings in their data security controls, but they relied on UDAP saying they were deceptive in the fact that they were marketing their data security as you know, a best in class, and that their protections were second to none. So the Bureau came in there, and then if you actually read through the consent order, it has nothing to do with their marketing of it, but actually their policies and procedures around data security. So they just backdoored in using UDAP. Resulted in a $100,000 penalty, but the target Dwala had to restructure their entire procedural suite. So you should be very careful when looking at your policies and procedures that you do not necessarily think facially trigger CFPB oversight, but they may be looking at that and then just applying those UDAP standards to whatever either cybersecurity or debt collection. When you actually read through the debt collection regulations, it reads very much like a UDAP statute. So be aware of that and adjust accordingly.
You know, and as we talk about the FDCPA, remember that there are certain debt collectors that are not covered, and then also certain groups that are exempted. You know, we've put these in here for your reference, but in essence, it is understand that there are certain circumstances where you're not going to trigger FDCPA third-party debt collection. And again, we always are a little bit hesitant to put this in because, you know, the states bring it back in. Two, because of that broad CFPB UDAP jurisdiction, it's possible that some of this comes back even though there's not facial application to your entity or your debt collectors because of the restrictions in the FDCPA. So just be aware that you know, these prohibition or these limitations exist, but be cognizant when you're asserting kind of blanket statements such as I'm not subject to the FDCPA, because it's unlikely that there is no way to rope you in through that provision.
Another thing we wanted to cover here, which is great insight as to how the Bureau looks at this, is the rule promulgation. Under Dodd-Frank, the CFPB, when it came into existence, was charged with restructuring debt collection regulations and overhauling the FDCPA. And at this point, it's ridiculous. You can see some of the timeline in that graph to the right there. ANPRM is the advance notice of proposed rulemaking. That started, or that the advance notice closed out in November of 2013, and that's 2 years after Dodd-Frank mandated that they look into it. The comment period then ended in 2014. Again, another comment period was opened up and closed out, and you see the rule activity continuing until you finally get down to the notice of proposed rule, the notice of proposed final rule that came out mid last year, with a commenting period ending in September of 2019. You're going to want to pay attention to what's in that final rule, because it's going to become a best practice, or you can see what the Bureau is thinking about when they're looking at debt collection.
You know, and as we look at that rule, it's attempting to update a lot of what may have been already in practice based on how the CFPB has been providing informal guidance. But, you know, it tries to clarify a number of positions in the FDCPA, including placing restrictions on how often you can attempt to contact someone by telephone. You know, it would require additional information on the debt itself, including, particularly important to us, itemizations of the debt, so that an individual can understand how that debt is broken out into late fees, default interest, etc. And what that is doing is, in essence, it's providing additional pitfalls you may fall into if that information is not correct. And then, most importantly, there's this very easy, they call it a tear-off, but you would actually have to provide a response mechanism for the consumer to easily send back a response to the collection attempt. You know, there's attempts to kind of clarify the intersection of TCPA and some of the voicemail, email, and text message communications with the requirements of the FDCPA. It's attempting to update how you provide disclosures electronically. We'll talk in a minute about an amicus brief that the Bureau recently filed. And what they're in essence saying is e-Sign Act applies, but you must have opt-ins specifically for collection communications in order for those to be valid disclosures. And then most importantly, would formalize prohibitions on collections of time-barred debts, making those express violations, and then shutting down certain CRA reporting, you know, until you have communicated with the consumer. You can't just start auto reporting without that necessary communication. So, you know, TBD, you know, as to when that proposed rulemaking will eventually go final. But, you know, we're kind of on the watch. As Craig said, it's been almost 7 years in the making. So we'll see when it finally comes into fruition. Craig,
in their annual report, they did say that's going to be this year. I mean, take that with a grain of salt. They said that almost every year for the last 3 or 4 years. But given the shift in their credit quality and the increase in defaults, I think there's going to be a push to get this out sooner than later, especially if you see that change in administration in November. This should start to creep into your thinking when you're looking at your risk assessments and your overall CMS. This is truly an overhaul. It's going to affect a lot of your procedures and fundamentally change your debt collection operational processes.
Now, the next few slides here kind of talk about where the CFPB has been going directly. And Craig and I'll attempt to give you just a little bit of an overview, but some of them are particularly important as we talk about the current crisis. We've got about 10 minutes left. Obviously, continue to shoot in your questions. If you have them, we'll attempt to respond to those as we go through. But we did want to give you this because it really is informative as to where we think the Bureau is going in the short term. So, Craig, you want to talk a little bit about the Wiley case?
Sure. So back in 2019, and just as an overview, these amicus briefs, if you're not particularly aware of where they're located, on the previous slide we have a link there to how to review them. It's always good for your compliance groups to routinely go in and just look at what amicus briefs the CFPB is filing. They really give you insight into the narrative of how the CFPB views some issues that may be considered a gray area for a certain area of law. So these are all, the gray areas of the FDCPA. So in Wiley, the Bureau filed an amicus brief arguing that the debt collector violates the FDCPA when it tells consumers that they must notify the creditor rather than the debt collector that a debt is disputed. We have the reg cite there. The FDCPA provides a means for consumers to challenge the alleged debt by properly notifying the debt collector that the debt is disputed. In the brief itself, the Bureau argued that the debt collector violated these provisions and engaged in a deceptive collection. Again, we see their UDAP language. When it tells consumers that it must notify the creditor rather than the debt collector that the debt is being disputed. The case was resolved without a decision to the particular issue around notifying the creditor, not just the debt collector. But you see that the Bureau obviously thinks that within the reg, it's inferred that you have to notify the debt collector, not the creditor, of the dispute.
Yeah, then we get to the Preston and Midland credit management decision. This deals with whether or not certain information on the outside of communications acted as a improper use of a language or symbol on a envelope, meaning you can't put notice of overdue debt, anything that would communicate the purpose of the contents of the letter. The actual stamp is that one that you see there, which is time-sensitive document. And the question was, is that a violation? Interestingly, the position the Bureau took, and it was consistent with the court, is there is no kind of, quote, benign language exception giving you an absolute right to put certain information on the outside of a communication. The only benign language that they recognized was information such as a return address or information that's mandated by the U.S. Postal Service. Anytime you're going to start trying to stamp the envelope to get the consumer's attention, you need to be careful because there is no absolute protection for you. And all of that will be kind of a facts and circumstances analysis, including the stamped time-sensitive document, which we see quite commonly in this type of collection process.
I don't know why that one comes up all the time. I see that a lot with operational units pushing back, and it doesn't mean anything to put this meaningless language on the envelope itself. That amicus brief is a great way of just pushing back on that. I don't know why. Just don't put anything on the envelope. It's the perfect. The next case, I believe I'm pronouncing it right, is Rodkivsky v. Clem. Here, the Bureau filed an amicus brief on the Supreme Court to address whether the FDCPA statute of limitations requires private plaintiffs to file suit within a year from the date of which the violation occurs, and if that incorporates a discovery rule, such as the 1-year period for bringing a suit begins to run only once the consumer discovers or should have discovered the alleged violation. So in December 2019, the Supreme Court unanimously held that the FDCPA statute of limitations begins to run when the violation occurs, not when the consumer discovers the violation. That kind of settled that issue.
And then similarly, you saw another case come through, Bender versus Elmore and Throop, which dealt with a similar issue, but there the Bureau filed a brief saying that consumers are not time barred from challenging FDCPA violations that occurred in the prior year when it alleges new particular conduct, even if it was the same type of conduct. This remains pending. The question is if it's a pattern, it's ongoing, there's an ongoing improper communication. Is it something where once the first improper communication starts, it sets the clock? Or is it something that every time a new communication is made, it resets? The Bureau's position is every time there is a violation, it resets the 1-year statute of limitation. TBD, to be determined what comes out of the court from that one.
Just to mention on that prior one too, that's litigation purposes for the private right of action. The regulatory, you're going to be cited with every violation. So it's ongoing, and the look back is, the look back is the look back. So make sure you treat them separately. The next slide, Brian. Next one, Adusky versus McCarthy and Halstus. Here, the Bureau filed a brief to determine whether the institution of non-judicial foreclosure proceedings constitute debt collection that is subject to regulation under the Debt Collection Practice Act. In 2019, the Supreme Court had a unanimous opinion stating a business engaged in no more than non-judicial foreclosure proceedings is not a debt collector under the FDCPA. They did highlight the exception in 1692 F6. It's worthwhile to go in and just make sure that you're not being deceptive, egregious, or if you're not being deceptive in the practices with the foreclosure proceeding.
Yeah, and this last one is particularly important here, which is a case, Lavallee versus Med1, dealt with the issue of communications that were provided electronically, particularly whether the written notice requirements of the FDCPA were subject to electronic disclosures. This is something to be addressed in the notice of proposed rulemaking. It would describe how you do electronic communications. Interestingly, here the court actually issued an opinion that Med1's emails didn't comply with the debt validation notice. One, because they merely provided a link to that information. They didn't actually substantively respond to the validation. And interestingly, the Bureau's position in this was absent an express consent to receive that type of notice electronically. This is not a valid validation of the debt. And so if you're planning to send any sort of these regulated communications electronically, very important that you comply with e-sign and then state UEDA restrictions. As Craig noted, that is subject to the proposed rule for debt collections, and hopefully that'll clarify a little bit of that. And then, Craig, we got a few minutes left. I guess let's cover a little bit of third-party oversight, and we'll continue to, if you have questions, feel free to send them in through the poll there on your screen.
Sure. So this is just touching on the best practices of third-party oversight. The board of directors and senior management are ultimately responsible for managing the activities, including those through a third party. The activities, because those activities are going to be handled as if the institution handled those activities themselves. It can outsource the task, but not the responsibility, and that there's ongoing diligence and oversight phases of third-party vendor management have become critical in light of the significant impact on customers through COVID-19. So there's going to be greater focus on what your vendors are doing. A lot of the vendor outsourcing is in the default spaces, so you're going to want to make sure that you're starting to refocus on those parties that are doing those services for you.
And when you think about debt collections, remember to think about it globally from kind of all avenues of risk, but particularly, debt collectors are considered a core vendor of any financial services company because it has such a major impact on these starred items here, particularly reputational and compliance risks associated with either third-party debt collectors or third-party debt buyers. I mean, it really is a significant risk factor and something the regulators are focusing on. We'll kind of jump through these next two slides. They're here for your reference. One is a set of vendor management guidances that were issued that really help you kind of understand and think through how you're evaluating those relationships. But I did want to provide a specific reference here for you. This is one of the best guidances on effective management of third-party debt collectors or third-party debt buyers. It comes from a set of OCC guidance on the topic. This is how the OCC instructs large national banks who are dealing with debt collectors and debt buyers to think about that process. What are the steps in evaluating those relationships, auditing those relationships, and what different aspects should be specifically addressed? We kind of view these as the hot list items. At a bare minimum, your third-party oversight regarding debt collections needs to be addressing each of these substantive areas because it in essence creates a nice handy-dandy checklist for you that you can work your way through as you think about that oversight and compliance role that you're fulfilling. Craig, any thoughts on that?
Yeah, one thing I want to mention here is a lot of institutions or entities have the oversight of various vendors either under IT or under ERM as a greater risk function. As you can see towards that second to last item in the process flow there, comply with applicable laws and regulations. No one outside the compliance group should be weighing in on their compliance with FCCPA, FCRA, GLBA, COA, or any other consumer lending reg or consumer protection regulation. If the process for oversight sits in a vertical that's not compliant, so just make sure you have a mechanism there that escalates the review of that vendor over. A lot of people do it through checklists. But as you're growing, or if you're a smaller institution, they don't have that checklist available. And if if some person walks down the hall and happens to ask, hey, can you look at this for a second, you have to really document how you're making sure that the vendor is complying with that. And an IT department employee or an ERM employee can't do that. It has to be someone in your legal or compliance department.
Great point there, Craig. At this point, we'll open up the floor to any questions you have, whether it deals with FDCPA or FCRA. Feel free to shoot those questions in. We'd be happy to answer those. In terms of key takeaways, the biggest are, this is going to be perhaps the most focused upon issue over the next 3 to 6 months. Make sure it's at the top of your compliance agenda in the near term, and particularly focus on the speed of these changes that are coming up. While we're waiting to see if any questions come in, I will tell you, and please let us know if you need invitations to these programs. Next Tuesday, we'll be doing a program on special asset and default management. That's Tuesday at 11 o'clock at our normal time. We'll be specifically focusing on special asset management techniques as well as tactics, and then how you're going to be working your way through consumer and commercial defaults if you're a lender. And then the following Thursday, one that's really great, we're having Linda Jensen, who is the chair of our data security group. She used to run a division at Travelers that specifically focused on data breach response and data security. She's going to be talking about some of the increased cybersecurity risks associated with the COVID-19 crisis, the current working environment, and how our customers are interacting with us as lenders or financial institutions. So feel free to shoot in your questions if you have any. We'll stay on the line here for a while, but would like to thank all of you for continuing to participate in these. Everyone will be getting a copy of the slides. Recording of this webinar will be posted on the website and available on YouTube for sharing. And we appreciate all that you are doing right now to maintain compliance and continue to assist customers as we go through this very trying time. We understand that you are truly in the trenches, and we want to be there to support you. So thank you. Stay safe. Stay well. And we'll stay on now for a few questions. However, we will be stopping the recording now. Thanks, everybody.
Thank you.
All right. Well, thank you, everybody. We'll be signing off. Always feel free to email or call with any questions you may have. Thank you so much for joining us today. Have a great afternoon.